let's start here with the wife who was next to him testifying about what she observed. And she specifically says, I saw the victim in this case, Chad Olson, his whole upper body leaning in. It freaked me out. I was terrified. Is that enough? Do you think the defendant really has to take the stand to say the same thing?
Yeah, I go back and forth on this because it's really difficult. Usually your default answer is you never want your client, the defendant, to take the stand. But this case is so much about his intent and his mental state and what he perceived and what fear he was in. And his wife there was terrifying. She uses the word terrified. I mean, that's good testimony for the defense. The other thing to keep in mind is that this is about how would a reasonable person react. But it's not so much a reasonable person like you or I in that position, but it's a reasonable person at his age, 71 years old, in a darkened theater, and would he maybe perceive things that, like popcorn, as a bigger threat than he might otherwise in a well-lit area and it being a younger man. And so I think that's the arguments the defense is trying to lay. The problem they're going to have is if he does take the stand, he's already given such a thorough interview, and there's going to be a lot for the prosecution to dig in with on cross-examination.
And what about the fact that you have witnesses who have described differently whether or not a cell phone was thrown? And some say no cell phone was thrown. The wife said cell phone was thrown, but then not the wife, the other witness, I'm sorry, an eyewitness in the movie theater. But then if you watch that testimony, here was her reenactment, and that was it. So she said a cell phone was thrown, but is that something, if that's all it was, that's really a threat? And so if he's on the stand, Josh, how do you deal with the fact that a cross-examination can really tear him apart to say, which one is it? How are we to believe that when so-and-so said this?
Right. And don't forget, there's videotape. I mean, he can talk about, he was jumping over the chair, or he really swung at me, or he threw that cell phone right in my face. But there's videotape to go back to. I've seen it, and it does not look, from my limited experience here, does not look as though there was a deadly threat to him or a threat of great bodily injury. And that's really the high hurdle that the defense is going to have to get to say that this interaction that appears to be, yes, violent, but somewhat innocuous on this videotape was enough for him to pull a gun and put a bullet into another man's chest.
Let me ask you this, because there's been some issue raised about the actual videotape and what was not seized as evidence immediately. If the video were longer, if it showed more of the room, if the lighting was different, if those things were true, could it be, Josh, that video paints a very different picture than what you just described based on what we've seen?
Yeah, I think so. And I know that the defense made a big issue about that. That's always kind of the defense's job, right? It's not just to defend your client, but you also have to put somebody on trial, and that's got to be law enforcement to show that maybe their investigation was not as thorough as it could have been. Had they gotten more of the tape, or had they preserved evidence in a better way, we would have known more about the truth of what took place. And each of those is that kind of death by 1,000 cuts defense that you're trying to put together to create that enough to create reasonable doubt in the minds of the jurors.
So, when we talk about self-defense, and to your point that when it is self-defense, often the defendant does need to testify because it is the reasonable person, what they thought as they were going through this experience, to basically try to say to the jury, it was self-defense because I believed I was at risk, right? That the threat was towards me. And so when you talk about this jury and this defendant, part of what we know is the interview that was on audio tape that we've heard during this trial. He is very matter of fact. I would say he sounds very ex-law enforcement and that he's telling the facts that happened, but he doesn't sound in his voice emotional. If he were to testify and have that same demeanor, could that potentially hurt him?
Absolutely. We've talked about this before, that he appears so kind of cavalier. It does not sound like the words or the voice or the inflection of someone who's just taken another person's life. I've described it. It sounds like he's back at the station with the boys kind of discussing something that took place that day on patrol, but it doesn't sound like he's really overwhelmed with the fear that he was going through, that he had to protect his own life with deadly force. And you're right, putting him on the stand, will he behave the same? He's now a much older man. It's been 6 years or so since this took place. How is he going to be able to hold up under very vigorous cross-examination? examination.
And Josh, you and I could tell great stories when we have some additional time someday about the fact that as an attorney, if you're a good trial attorney and you prepare your witness, of course you're telling them to tell the truth, but you never know what's going to happen once they take the stand in terms of their demeanor, their tone. Sometimes they choose to embellish or add things or, oh, I'd forgotten, and you just think, well, here we go, because you just don't know what to expect when they actually take the stand. So it remains to be seen, will Curtis Reeves take the stand? We'll have to keep watching.